It's our commitment to impart knowledge in the field of legal as well as other various fields which are directly or indirectly connected to us. We have to see that the knowledge should not be theoretical, it should be practical also. As one of the hot issue or the present issue is that most of the construction is going on in around Mumbai. All those buildings or the approval is sanctioned or governed or regulated by RERA. Today we have got one of the expert advocate in this field. He is none other than Advocate Sulaiman Bhimani. Before proceeding further, I would like to just request Honorable President Sahib to welcome him with a bouquet as a mark of respect and love and affection to him. Thank you. Just a brief introduction of today's speaker. He normally practices in Cooperative Society, MCS Act, Consumer Forum. He is one of the experts in RERA. His articles are widely published in newspaper. He has also taken various orders in favor of agreed home buyers, which are widely published in the newspaper. Not only this, he is the founder and president of NGO called the Citizensjusticeeforum, which is primarily functioning to address and resolve the grievances of masses of large, particularly those sections of the society who are underprivileged, ignorant and unaware of their legal rights. He is going to deliver a lecture for a period of 45 minutes on which he will cover almost all the aspects of the topics of the RERA, which are very much connected to us, relevant to us. And the 15 minutes will be for an interactive session, that is the question and answers. If anybody has any questions, you will given the opportunity to ask him. That will be clarified or explained by the honorable speaker today. Only request is that we have got a highly sophisticated instrument that is called mobile. Please keep it in mute position or in vibrate position so that you are not disturbed and others are not disturbed. And the program can be conducted in a very smooth and friendly manner. Without wasting much time, I am handing over the mic to today's speaker. Once again, I welcome him. Very warm welcome to our Bar Association. Busy advocate, just like you. He has taken some time. His eagerness to help other advocates, that is important. We are not n number of advocates who are having better knowledge than us, but not eager to help us. So, it's an honor and privilege, Bhimani sir, to welcome our Bar Association, and here's the mic for you.
Good evening, all of you. I have a hearing problem. When I say good evening and I don't hear back, good evening. Let me check, because last year I had gone for a loss of hearing operation. The doctor was from Bihar. So he did not do a good job. So let me check. If you don't say good evening, then I feel that advocates of Vikhroli Bar Association at 5 p.m. they go to sleep wherever they are with their eyes open. So let me check. Good evening.
Good evening.
Yeah, that's good. Now, there was lot of talk about RERA, right? And everybody is curious because you have not read the books, but it is a very simple act. You should know only 6 to 8 sections of the RERA and you can master that RERA act. It is not a very rocket science. But before RERA there was a MOFA. Yes or no?
Yes.
Right? So before RERA coming into force, has anybody fought a case for an aggrieved home buyer? Please raise your hands. Under MOFA? Okay. Have you gone for purchase of the flat or booking of the flat? Yes. So what was happening is, you gave the money to the builder and you give it very fast, lakhs and lakhs of rupees and crores of rupees, because the price is going to increase. That greed is there. आज ले लो, कल भाव बढ़ जाएगा. Now the bidder was taking undue advantage of your greed. He used to give you allotment letter. He was not giving you agreement. Then after paying more than 50-60% of the amount, then you were behind the bidder. That abhi agreement register karo. Abhi agreement register karo. Then bidder one day used to call you at the sub-registrar office. He will make you sit. He will take the photograph, put your thumb impression and sign. And after a follow-up of 4 to 6 weeks, you will get the agreement. But you never knew the content of the agreement, what is written, what is the area, right? When bidder used to sell, he used to sell that it is 1000 square feet build up, but actually you are getting 500 square feet carpet area. So that transparency was not there. That date of possession was kept blank. And the sub-registrar also was accepting that blank date of the possession, and the agreement used to get registered. Now what was happening is, the builder was taking the undue advantage of your ignorance. Even at that time MOFA was there, and MOFA clearly said that if you are taking more than 20% of the amount, you have to register an agreement, right? Now one thing, even RERA has not given you all the solutions, but one thing is there, that on the website, if the project is registered on the RERA, then you get to know the model agreement, date of possession is mentioned, and the carpet area is mentioned. So the transparency and accountability till this stage the RERA is able to give you. But RERA is not giving you the entire solution. Like SRA, it doesn't come under the ambit of the RERA. And in redevelopment project, the existing members, they also don't come into the ambit of the RERA. Only the home buyers, the definition of allottees is that when you purchase a flat, you become an allottee. So their complaint is only entertained into the RERA. Now let's see what are the 5-fold objects of the RERA. To establish the Real Estate Regulatory Authority. Now I'll take you back to 1992. A big scam happened in stock market. Anybody is aware of that? In 1992 I'm talking about. Harshad Mehta scam? Yes? Yeah. So after that, SEBI was formed to regulate, but then also the scams are happening, but not to that extent. Now latest what we saw is of the Adani. But in previous days it was happening, every month there was, then after the Harshad Mehta, then Ketan Parekh was there, then so many else were involved in it, but SEBI as a body is regulating that stock market. So similarly, the RERA wants to regulate the housing industry, the construction industry, because every time the home buyer was taken for a ride. And to promote the real estate sector, the third is to ensure sale of real estate project in an efficient and transparent manner. What is efficient? The area is specified, the carpet area, then date of possession is specified, and it cannot be a one-sided agreement. If there is a one-sided agreement, you can complain to RERA. To protect the interests of the home buyers in the real estate sector, to establish an educating mechanism for speedy dispute redressal. Go to the next slide. Important aspects under RERA. Provision pertaining to the following. the promoters, because in the previous days there was a sales office, we did not knew who is the promoter, because only we knew the sales people, right? So now in RERA you will know who are the promoters, their photographs are also there, and what project they have undertaken in the past. So you have to do a little bit of research. Then the real estate agents also have to register in the RERA. So that is a very big step they have taken. Then allottees, the consumer, concerned authorities and miscellaneous. Next. Dear Mr. Promoter, say hi to the new key to your treasure box. Why there is a key to the treasure box? Because until and unless you don't register yourself in RERA, you cannot advertise, you cannot sell. So this is the first thing, that if a builder wants to advertise or sell the units, flats or shops, he has to register under RERA. And it is a very simple, you have to go to this RERA website. You can register as a builder also, and you can register your complaint also against the builder. Next. Section 3 of RERA says, no promoter shall advertise, market, book, sell or offer to sell or invite persons to purchase in any manner any plot, apartment or building in real estate project in any planning area without registering the real estate project with the RERA. So in whichever state, in Maharashtra we have RERA, in Andhra Pradesh they have RERA, in Patna they have, in Bihar they have RERA. So everywhere there is a RERA, but there will be little modification up to the state. And section 59 of RERA, penalty up to 10% of the estimate cost of project. This is very important. This was not there in MOFA first. If the above penalty is not paid and violations continues, promoter shall be punished with imprisonment which may extend to 3 years, or fine which may extend to further 10% of the estimate cost of project. If suppose the cost of project is 200 crore, so 10% is how much? 20 crores. It's a big amount, right? Validity of registration till the date of completion or stated by the promoter. Now suppose promoter says by 2025 I will complete this project, so the validity of that registration is up to 2025. If he is not able to complete, then he has to apply for 1 more year's extension. Extension of registration may be extended due to circumstances beyond control of the promoter, force majeure, namely flood, drought, fire, cyclone, earthquake or other natural calamities. Now 1 year extension automatically has been given by the RERA. You know the reason why? What happened in 2020? Pandemic, COVID. So due to COVID, 1 year extension has been given by the RERA. Next. Exemptions from registration. Area of land proposed to be developed does not exceed more than 500 square meters. If the plot area is less than 500 square meters, the RERA registration is not required. Number of apartments proposed to be developed does not exceed 8, or it is less than 8, then also the registration of RERA is not required. Where promoter has received completion certificate prior to 1st May 2017. So he doesn't need to register that project. Ongoing projects to register prior to 1st August 2017, but still there are some projects which have been not registered, they were stored, now they are getting it registered. Projects for 3 Rs not involving marketing, advertising, selling or allotment, that is repairing, renovation, restoration, redevelopment, where there is no sale component is there, they did not be registered under RERA. Next. Promoter, let's spit it all out. Disclosures in application, section 4, subsection 2. details of project constructed in past 5 years. He has to come out with that these are the projects which I have constructed in the last 5 years. So we can come to know whether the builder is a good builder or not. Nowadays it is very simple. You have to type in Google about the builder and so many things, good reviews, bad reviews will come out, any case are pending, they will also come out. So you have to make a judgment whether this builder is good, where can I part the money with the builder or not. Authenticated copies of approvals and commencement certificates. Initially, if you go, even today also, if you go to any sales office, they will show you the floor plan, that is called the sale plan. They will not show you the approved plan. What is approved by the corporation or what is approved by the panchayat, they will not show you. But if you go to the RERA website, they have to upload that plan. So you have to verify that what the plan is sanctioned by the corporation and what the sale plan, are they matching or not. So this is one point you are getting it, where the transparency is there. And now if it is in MCGM, you can go to the DCR of MCGM and find out the OC, CC or IOD, IOA, whatever is there, the flow chart is there. From the going to the MCGM website, you can find out at what stage they have obtained the commencement certificate up to 5th floor or 10th floor, and then you can take a decision of buying or ignoring that builder. Then proposed facilities and amenities. Initially they used to give a very good brochure that swimming pool is there, clubhouse is there, this is there. Then after that open space or that clubhouse, you will find one more building coming up and your open space is gone. So in RERA, everything he has to mention on the first go. Or he can say that this will be developed on a phase wise, but he cannot change the plan. If he has given you that clubhouse, he has to give the clubhouse. Without taking consent of all the home buyers, he cannot change that plan. So this is very important. Number and areas of garages for sale. Where promoter is not owner, agreement entered into between the promoter and such owner. Now what happens? Many a times I am the landowner and Samadhan comes to me as a builder. He says, your land is there, I will construct the building and we will sell all the flats to the bar association members. But I have to, and he has to declare the land belongs to me and he is only constructing it and then the selling. So everything, that transparency is there, nothing is left on assumption. FSI, TDR and other entitlements which are proposed to be utilized. Aggregate area in square meters of the recreation and open space. So what is the open space? He has to specify on day one. This is the open space, this is the clubhouse, this is the swimming pool. Whatever is there, he has to specify on day one and he cannot change. If he has said this much open space, then he has to adhere to that plan and he has to give it to you. Next. Then he has to swear that legal title, he has to upload that on the RERA website. No encumbrances, date of completion means date of possession. 70% of the amount collected from the allottees to be deposited in schedule bank to cover cost of construction, or else the penalty up to 5% of the estimate cost of project. Now what happens, I'll tell you the beauty of the RERA is, now suppose Samadhan is the builder and I give 10 lakh rupees to him. So out of that 10 lakh rupees, 7 lakhs has to be utilized for the construction, 3 lakhs he can use for the admin purpose to pay salaries to the staff or take some profit at home. But 70% has to go into that project. It cannot be diverted. Initially what used to happen, that I as a builder used to take the money and I used to divert that money by buying another plot and the construction was not going on. Or I used to spend lavishly on my children's marriage. That has also happened. There are so many cases and the construction work is not going on. So there is a cap. There has to be a certificate from the architect. There has to be a certificate from the architect that this much work is done and he can only withdraw that much amount. 70% has to be utilized in the construction of the work. Next. Mr. Promoter, watch your footsteps. section 7. This is very important. Now you have to keep it in mind. If you want to practice in RERA or if the client comes to you, this is the section which you have to remember. I'll give you where there are only 7 to 8 important sections. If you master that, you will become more expert than me. Revocation of registration. Authority may revoke a registration on being satisfied that the promoter is defaulted in doing anything required under the Act, rules, regulations. The promoter violated terms and conditions of approval. The promoter is involved in unfair or fraudulent practice or irregularities. Consequences: no access to its website. Name of the promoter to appear in list of defaulters on the website. Deregistration communicated to the authority in other states. Suppose if the builder defaults here, he is delisted, blacklisted here, that information will go to other 29 states of India, that he is blacklisted here, so he cannot have one more project there until and unless he clears the name here. Freezing of bank account with the scheduled bank. What is the status of the project post revocation of registration? Section 8. Now section 8 is also very important. Section 8 says the allottees will have the right to refusal. But normally I promote my allottees, the home buyers, executive home buyers, that once the project is deregistered, we step into the shoes of the builders, we take the project and we complete it. So we have the right. Now suppose 80-70% of the work is completed and there are unsold inventories and there are certain amounts which has to be paid by the allottees. So let that money be spent on completion of the project so that everybody is not awaiting. The anxiety level is not increasing because the project is in our control. We are using our money. We are paying to the contractor and completing the project. And we are not at the mercy of the builder. Next, functions and duties of promoter, section 11. He has to maintain the website and that is linked with the RERA. So RERA can any time block that website if they found that it is involved in unfair trade practice. So they can block that website. During booking, issue of allotment letter. So up to 10% of amount which you pay to the builder, he has to issue an allotment letter. And the moment 1%, suppose now the flat CV, the consideration value is of 1 crore. What is 10%? 10 lakhs. So till 10 lakhs he can issue a allotment letter. Now after 10 lakh, if he is asking you for only 1000 rupees also, he has to register an agreement, then only he can demand further money. Till then he cannot demand any money. About 10%, he has to enter into a registered agreement. Next, website I explained to create a web page, enter details as stated in section 4, subsection 2 and quarterly updates on the project. So every quarterly he has to update that this is the stage of construction. Suppose in the month of September he said the 5 floors are constructed. In December he will have to come and say that further 2 floors have been constructed and these are the bookings I have got from September to December, 10 more flats have been booked. So you come to know that what is the status of the project financially also and physically also, what is the progress of the work. Disclose advertisement and prospectus. Next, during booking and issue of allotment letter, disclose sanction plans, layout plans, approved by competent authority. That is, if it is in Mumbai, it comes to MCGM. If it is in Thane, it comes to TMC. If it is far beyond, then the Gram Panchayat. Disclose stage-wise schedule of completion of the project, including the provision of civic infrastructure like water, sanitation and electricity. This is the right of the allottee to know all this, what are the stages of the construction. Fulfill obligations and functions as stated in the Act, rules and regulation and agreement for sale. Obtain completion certificate and occupation certificate. Now you know how many buildings in Mumbai don't have occupation certificate? Any number? Any wild guess? Almost 30 to 40,000 buildings don't have occupation certificate. So with RERA, there is a news on their neck that you have to obtain the occupation certificate. Then only they can give you the possession. But there are many judgments before that also by the High Court that you cannot occupy any unit which doesn't have an occupation certificate. But still, because of our greed and ignorance, we fall into that trap. And then when the building is going for a redevelopment, these issues crop up and then you are not able to redevelop your own building. Obtain lease certificate where the real estate project is developed on a leasehold land. Form a legal entity like association, society or cooperative society with 3 months from the date on which 51% of the total number of allottees in the building have booked their flat. This is very important, kindly note this. What does that sentence says? Booked, not executed agreement, not purchased. I have booked, and suppose now there are 100 units and we 51 people book in a project. So now we have crossed that threshold of 51%. So it is the obligation of the builder to form a society or an association. If he doesn't form, we can form it. So this was not there previously. This is a very important aspect which you should know. The moment any client comes to go to the RERA website and find out how many units are to be constructed and how many units are booked. That you will find it in the RERA website. The moment it crosses 51%, you write a notice to the builder that as per the RERA provision, you have to form an association or a society. And this is very important because the moment you form the society, at the time of possession, he is not going to ask you for 2 years maintenance, 2 years property tax in advance, because the society will take care. Initially, builder was keeping that money and he is never accounted that money to the society. There are so many cases we are fighting similar to that. Pay all outstandings collected from the allottees till physical possession is transferred. Not to mortgage, create any charge on property after execution of agreement for sale. Cancel allotment only on terms of agreement of sale. Now these are very important sections. 7, 8. Now you just keep a note of this. In the morning you get up at 7. Then 8 breakfast. 12 is normally a lunch time, or you prepare for a lunch. So according to that you can remember these sections. 12, 13, 14, 15. Then one more section is there, that is 18. So 6 o'clock everybody wants to go home, wherever they are, whether they are practicing advocates or whether they are working in the office. So this is the way you can link and remember that these are the important sections. Loss sustained due to incorrect or false statement in advertisement or prospectus. Now he is giving a very tall promise, very big audience, very big advertisement that there will be a swimming pool, there will be a clubhouse, there will be a jogging track. So everything you have to keep a proof of that, and if he is not giving you that amenities, under section 12 we can file a complaint under RERA. It's that simple. Section 13, no agreement for sale, no advance deposit. Means the moment he asking you more than 10%, then what is to be done? He has to execute an agreement. Till then 10% allotment letter is fine. The moment he is asking you more than 10%, he has to go for the execution of the agreement. Section 14, very important. Adherence to sanction plans. Promoter squad cannot act without the consumer's nod. Suppose if he comes after some time that instead of swimming pool, I am changing this, I am going to make one building here, and swimming pool I will purchase that land, after that plot we adjust it to the plot and I will construct a swimming pool there. You say no, because you have that right, the RERA is given you. So without your consent, he cannot change the plan. This is very important. Allottees specify and promoters rectify. So section 14 is he has to adhere to the plan. He cannot change the plan. Section 15, obligation of promoter in case of transfer of a real estate project to a third party. Now suppose Samadhan is a builder. Now he wants to retire or he is very fed up. Now he wants to give it to Mr. Bhimani that you take the project and you complete it. For that also Samadhan has to take the consent of all of you. If you all agree, then only a third party interest can be created. Till then, he cannot, because he cannot trade us. Initially what used to happen, one builder used to come, he has to do the agreement, then the third, he was trading you. He will give to the third party and he will give to another third party, and it was keep going, changing hands from one end to another. Next, 16. It is not that important, but insurance of real estate project. Section 17, transfer of title, conveyance and common area. Now this is very important. The moment he gets the occupation certificate, he has to transfer and do the conveyance of the common area and of the plot to the society. Now the heart of the RERA lies in the section 18. Kindly note down, because most of the cases are fought under section 18 or under section 12. Now, promise broken, let money apologize, right of LOT, interest plus compensation or interest. Now, in section 18, there are two provisions, there are two options for a home buyer. What are the options? If the builder is not able to give the possession as promised, say December 2022 was the date, right? Now I have the right to withdraw from the project and take interest as specified in the RERA, that is State Bank of India's lending rate plus 2%. From the date of money I have given to the builder. Now what is the State Bank of India lending rate? Say 7%. So how much I will get back as an interest? 7 plus 2, 9%. So from the date of money, suppose I have booked the flat in 2013 and now the RERA order comes. So from 2013 to 2022, 9 years interest at the rate of 9% I will get. So I will get the double the amount of the money what I have already paid to the builder. So this is very important. Then one more option is there, because it is near to my workplace. Now this is a Vikhroli Bar Association and I have booked a flat opposite to the building and I am practicing in Vikhroli Bar, right? So I don't want to exit because hardly 30 feet and I am there in my workplace. So I want to continue in that project. So in that case, what is the option? I will ask for the interest for the delayed period. Now if he has promised me December 2020 as a date of possession or as a date of completion of the project, but even after 3 years it is still pending, but it is almost 90% complete. So whenever he completes, say he completes in December 2024, so I will get interest for the 4 years from the date of default till the actual date of possession with occupation certificate. And don't fall into the prey of that this is a soft possession, this is a fit out possession. There is no concept, there is no term legally of soft possession or fit out possession. So section 18, you have two rights: to exit from the project or continue in the project and get the interest for the delayed period. So this is very important. These two sections, if you remember, any client comes, you can take the matter and it is very simple. You can call to my office, they will help you how to upload the complaint. And one thing is good about the RERA is that whatever the matter comes on that board on that day, it is an online hearing. All the matters are heard. The board never collapses. Only it happens in the appellate tribunal and in the High Court. So that is the one beauty, that if the matter is listed, it is definitely going to be heard. In very rare case, suppose if something happens to the presiding officer and is not able to attend, that's a different thing, but it is an online You can attend the meeting through your mobile, through your laptop, anywhere. So this is, you can have one more additional, branch of practice while attending in the Vikhroli court also. And suppose if the matter is going to take place, sometime you open your laptop or mobile, you attend and do the argument. And the arguments are also very simple, not very tough. Then Section 61, contravention of any provision except Section 3 and Section 4 or rules or regulations made, penalty is up to 5% at the estimate cost of project. So the cost of the project is 200 crore and the RERA implies a penalty of 5%. So what will be that amount? 10 crores. Right? So it's a big amount for the builder. So they will try not to do any such type of things. Next. Now this is about agents. Now agents also have to register when they are going to sell any RERA registered project that is under construction. No real estate agent shall facilitate sale or purchase of any plot, apartment or building in real estate project registered under Section 3 without obtaining registration. So he has to obtain a registration. Documents accompanying application, one photograph, income tax return for the last 3 years, proof of address of principal place of business, telephone numbers, etc. Details of civil and criminal cases any pending. Initially we never knew that what are the criminal cases are pending against this estate agent. But he was very sweet because whenever you go to his office, he will offer you tea, coffee, biscuits, and you think that he is a godman. And then he swindles your money, and then after 5 years you realize that you curse him. So these things are taken care of by the RERA. Next, validity of registration. Registration to be valid for a period of 5 years. Registration number to be mentioned in every sale facilitated by the agent. So he has to specify that this is my RERA registration number. Bar on registration. No fresh application shall be accepted for a period of 6 months from the date of revocation or suspension of registration. This is for the estate agents. Next. Functions of real estate agents. Not facilitate the sale or purchase of any plot, apartment or building in an unregistered real estate project. This is a crime. Maintain and preserve prescribed books of account and documents as prescribed under RERA. Facilitate the possession of all the information. Penalty up to 5% for estate agent. Suppose now the flat cost is 50 lakhs and the penalty is imposed on him of say 5%. What will be that penalty? Valuation? 2.5 lakhs. So it's a big amount for estate agent. So he will see that he doesn't fall into such type of doing any contravention which is against the RERA rule. The other side of the coin, LOTs, you are also not exempted. Now normally, we take the side, I always fight for the home buyers. Hardly any bidder comes to me to fight their case because they know that he is only interested in giving justice to the aggrieved home buyers. Now, but here, if the bidder delays, we have the right to take the interest from him. What is the rate of interest? State Bank of India's lending rate plus 2%. In case, if I as an LOT delay the payment to the bidder, the rule applies the same. I will also have to pay the interest at the rate of 9%. But initially, if you see the agreement, the builder used to say that if you delay the LOT, they will charge you 24%. And if they delay, it was 9%. So RERA has come out, whether the builder delays or the home buyer delays, it is 7 plus 2, that is 9%. Delay in payment of above charges will attract penalty, payment of interest. Take physical possession within 2 months of the issuance of the occupation certificate. The moment builder sends you a letter with a copy of occupation certificate that he has obtained, you have to take the possession within 2 months. Participates towards the formation of a legal entity, that is society, association of LOTs or cooperative society. So you cannot say no, I will not be a part of the cooperative society or association. Authorities under RERA, Real Estate Regulatory Authority. Composition, 1 chairperson and minimum 2 whole-time members. Filing of complaints. Complaint may be filed by the aggrieved person under section 31 of the Act for violation of the Act, rules or regulations. Manner of implementation of order. In the same manner as it were a decree or order made by the principal civil court or original jurisdiction in a suit, or send the order to the principal civil court for execution. Here I am not happy because I have obtained many orders in favor of the aggrieved home buyers. But execution of the order is very poor. So recently also High Court has come out on that RERA, because RERA orders are not taken seriously by the builders. And nowadays, they play with so many things around with the current chairman, Ajoy Mehta, who was first MC and then he was an housing secretary also. So all the builders in you right from the beginning. So sometimes or deliberately or by mistake he gives such an order which is the builder, the home buyer feels that it is in my favor. But somewhere he will put a comma or change word here and there, and then instead of going to the appeal, suppose if he goes to the appeal, so when the chairperson Indra Jain was there in the appellate tribunal of RERA, she used to say you deposit 100% of the amount, then only your appeal will be heard. So they go to the review of the order without paying anything. Today only we had the hearing. I am coming to that what are the other side of the RERA. There are good side also and there are negative side also. So you should be prepared for that. Next, the address of hearing is Bandra East, Bandra Kurula Complex and Churchgate for the Mumbai. And there we have in Pune also, in Nagpur also. Now disposal period is under section 29 is within 60 days. But this is not happening. Initially used to happen that the first order was pronounced within 15 days. And we used to get the judgments, the order within 2 to 6 months. But nowadays the hearing doesn't come before 6 months. So as an advocate, I prefer to go into the consumer court than into the RERA. There are many reasons which I am going to explain. But in certain cases where you have to go to the RERA, but when the amount is big, and suppose if it is more than 50 lakhs to 2 crore where the home buyer has paid, so it is better we should go to the state commission. There are various other reasons. In RERA, initially I used to take the order of compensation for 5 crores. Then it came down to 2 crores. Then 1,50,000. Now the compensation is only 20,000 and 7 plus 2, 9% interest rate. But in consumer court, you can file the compensation for the unfair trade practice, mental agony, and they apply their judicial mind. The presiding officer of the consumer court, they apply because they come from the judicial background. In RERA, initially all the presiding officers were, I would say name them, was Balchandra Kapadnis, he was a retired judge, then Madhav Kulkarni, retired judge. So they used to apply their judicial mind and then they used to give a reasoned order. But now all the presiding officers of RERA are IAS officers, so they don't apply their judicial mind, they apply some other mind, which I don't want to tell. Stages of inquiry after filing the complaint. Appearance of party, recording of plea of the respondent. If pleads guilty, then order. If not plead guilty, then the explanation, reply to be filed by the respondent. Reading the evidence, oral or documentary, final arguments, and then final order. So only the 5 stages are there. And this, even if they take it seriously, even the RERA complaints can be disposed of within 6 months. But I don't know why it is not happening. The Real Estate Appellate Tribunal. Composition, 1 chairperson, minimum 2 whole-time members, 1 being a judicial member and other technical administrative member. So here there is a bar that one member has to be a judicial member. Other two can be technical or IAS officer. Judicial try appeals from the order of the Real Estate Regulatory Authority, and that too he has to do it within 60 days. Period of limitation, within 60 days from the date on which the copy of order is received. The moment he receives the copy of the order, within 60 days he has to file the complaint. Manner of implementation of orders. Orders to be executed by the appellate tribunal as a degree of a civil code. And if you are not satisfied, either the builder or the home buyer, then he has to go to the appeal to the High Court. That is also within 60 days from the date of communication of the order of the appellate tribunal. Now I'll give you one practical example. Now, as an RERA, I first file a complaint in RERA, I get an order, then instead of going to the appeal now, there are advocates who are smart, the builder hires the smart advocates, he will go for the review, then the review he will take 6 to 8 months or maybe 1 year, then he will say no, you go to the appeal, then after the appeal it goes to the High Court, and from the High Court it goes to the Supreme Court. But in case if the amount is more than 2 crores, so it is better to go to the NCDRC. Now what happens in the NCDRC? There is only one step ahead, that is Supreme Court. So there are hardly any orders which the Supreme Court has not upheld of the NCDRC. All the orders of the NCDRC against the builders are upheld. So that is a shortcut if it is more than 2 crores. If it is between 50 lakhs to 2 crores, then you go to the State Commission, and then you will go to the NCDRC and the Supreme Court. So the time is saved. And there are many judgments which there on this thing, laptop, which I will show it to you. Consequence of breach of order. Promoter, section 64, imprisonment maximum 3 years or fine up to 10% of the estimate cost of project or both. But this has never happened. I have got an order where the builder was penalized, but after that no action has been taken by the RERA. So no money has been recovered. For real estate agent it is section 66, maximum 1 year or fine less than 10% of the estimated cost of the plot, apartment, building for which the sale or purchase has been facilitated or both. For LOT, section 68, imprisonment maximum 1 year or fine up to 10% of the estimated cost of the building, plot, apartment or both. Power of jurisdiction. Now initially, people used to go to the High Court that the builder is not giving me possession. Now the section 79, this you have to keep it in mind. You cannot go to the High Court. There is a power of jurisdiction because either you go to the RERA or consumer court. Civil courts to have no jurisdiction. Cognizance of offence under section 18. No court shall take cognizance of any offence punishable under this act. Rate of interest payable by the promoter and the allotee. State Bank of India highest marginal cost of lending rate plus 2%. Timelines for refund within 30 days from the date on which such refund becomes due and payable to the allotee. Now this is very important. The RERA gives a clear cut message about the parking space. Open parking area, this has been clearly included in the definition of common areas which need to be conveyed to the association of the allotee after the occupation certificate is obtained. Sale or allotment of open parking areas by the promoter is not permissible. He cannot sell any open parking space. Covered parking, as defined in the Act, is permitted to be sold. Garage, as defined in the Act, is permitted to be sold. So only covered parking can be sold. Yeah, this topic. Acha, now there are judgments. Next slide. Now, there was a case before RERA, just before me, when I could appear and argue. The chairman of that time of RERA, he refused to entertain the complaint because the date of possession was not mentioned in the agreement. It was kept blank. Fortunately, there was identical matter which came to me, and it was placed before Balchandra Kapatnis, retired judge. And I relied upon this Fortune Infrastructure, known as Hicon Infrastructure and others, versus Trevor Di Mela and others on March 12, 2018. So there was an NCDRC judgment that after taking more than 20% of the amount, the builder has to complete the building within 3 years, and that is a reasonable. So my argument was on that, but they said that since it's an NCDRC judgment, we cannot rely upon it. And subsequent date was given, and meantime, that builder challenged that NCDRC order in the Supreme Court, and Supreme Court upheld the same. Now, once Supreme Court passes an order, it becomes a law. So in the next date, I came with that Supreme Court order that 3 years is a reasonable time. My client had booked in 2012, and now it is 2019, 7 years, and there is no way, it is not, building is not even halfway completed. So I want the refund. So that was the first order in the RERA where the date of possession was not specified and the refund was granted to the allottee. And it was widely published in all the newspapers. So what I will do is, when the video is uploaded, whatever the judgment you see, I will link that judgment now. How we have, you have seen the Advocate Vinod Sampat's video. Whatever he quoted, whatever he specified, all that links are provided in the description box. So whenever you listen to that video and you want to see that judgment or you want to see that circular, you just click and it will open up, so that you are anywhere with a mobile, wherever you are there, you can just open it and you can even argue your case also. Then Pioneer Urban Land Infrastructure versus Govind Raghavan, 2nd April 2019. In this case, the learned Supreme Court held the buyer can be expected to wait for a reasonable period and not indefinitely. Also, proceedings under Indian Bankruptcy Code 2016 IBC and RERA can sustain parallelly. Even there is one more judgment in the India law that also I will put, it has just published, that RERA, even if there is a SURFACI Act proceeding going on, the RERA has the upper hand. Then because a home buyer who has parted his money, hard-earned money, for a dream house, he should be protected. So that judgment will also be there. Then Manjit Singh Dariwal versus JBPT Properties Private Limited. In this case, learned RERA Appellate Authority observed that the complaint filed on the basis of allotment letter is valid and complaint of allottees will not fall for the want of agreement of sale. So initially, some of the presiding officers in RERA say you have an allotment letter, so your complaint is not maintainable because you don't have the agreement. But in the same RERA, Balchandra Kapatnis has held that even allotment letter is a part of agreement. It is an agreement. I have given you the money and you have issued me an allotment letter with mentioning that this is the consideration value and this is the date of possession. Or even for that, the possession date is also not mentioned, but you have taken money and you have given something in writing in that consideration. So that is also an agreement. Then the Neil Kamal Realtors is a very huge judgment, but that also I have made a link and I will see that everybody gets. In this case, Learned Bombay High Court held that the provisions of RERA are extant, retroactive or quasi-retroactive, and Parliament has the power to legislate even such provisions and are not ultra-vires to the Constitution. Techno Drive Engineers versus Indus Infra on 26 November 2019. In this case, Learned RERA held that only residential and commercial projects come in ambit of RERA and not industrial project. So this is very important. You should know that if you are dealing with any industrial gala, they don't come in the ambit of the RERA. Anita Castellano versus Messrs. Godrej Landmark Redevelopers Private Limited. In this case, RERA observed that section 12 and 18. Initially, I told her these are the sections which you have to keep in mind, that is 12 and 18 operate at two separate times of the transaction. Section 12, which relates to the validity of the adjustment, which is prior to signing of the agreement, and post execution of the agreement, section 18 can be invoked. So these are two very important sections if you want to practice in RERA, or you should be aware of it. RERA versus Piramal Realty Glider Buildcon Realtors on 5th April 2018. In this case, Supreme Court held that the regular updates pertaining to the progress of the project should be provided by the builder to the allottees. Ajay Nagpal versus Today Homes and Infrastructure Private Limited dated April 17, 2019. In this judgment, RERA held that an aggrieved home buyer has now an option to initiate legal proceedings against the errant developer builder in either RERA or consumer courts, but it has to be seen with these complaints are timely concluded or some relief is provided to the aggrieved home buyers. So you have the two options. You can go to the consumer court and to the RERA. And these all are judgment. I don't want to take much of the time, but this will be all available. Now in this last judgment, Brijesh Hirji versus Skyline Construction Company on 21st February 2019. In this case, RERA held that no date of possession in the agreement of sale is a violation of section 13 of RERA as well as the section 4 of MOFA. This case was personally argued by me and it was widely published in all the newspapers. And Brijesh Hirji is a actor who has featured in Golmaal, that Sapola type. So thank you all, and these are my contact numbers, and if you have any questions to myself and Advocate Sampat are there.
Sulaiman is like a king, and as far as RERA is concerned, the work speaks for itself. Secondly, just now only the agent's manual has been uploaded by RERA, which since I was out and Sulaiman Bhai was in a lecture, so I thought it would be more appropriate for me to download it on the group. Thirdly, in that particular agent's manual, there is one FAQ section. We cannot open the FAQ section, but for that you may have to go to the RERA website. And from there I will request all of you to go through it. And I will request Sulaiman Bhai that when he is preparing his speech and is giving us copies of all these judgments plus this, he will be kind enough to send the link of those question answers so that it will educate all of us. My son regularly interacts with Sulaiman Bhai. My son is the secretary of the RERA Practitioners Association, and they regularly interact, and he has been many times called by Sulaiman Bhai for his particular lectures. Believe me, friends, as advocates, we have always to learn. Learning is a continuous process, and all of us will stand to gain a lot if we expand our horizon, because these are the days not of working alone but to work as a team. And for RERA things at any point of time, whether it is a friendly advice or a professional advice, Sulaiman Bhai is always available. I have my personal experience with him, and we are friends for more than 20 years, having interacted and intermingled with each other a number of times, and he is so much helpful that you won't feel you are meeting a stranger. You are meeting one amongst yourself, and you will find it when you talk to him. Any clarifications or RERA is there, he always helps advocates. We are thankful, all of us, to Samadhan ji for bringing a Samadhan of knowledge, experts, and interaction of one and all. Thank you.
तरी माझ्या सर्व वकील बांधवांना आणि भगिनींना विनंती आहे, तुमचे काय प्रश्न असेल एकेकाने भीमानी साहेबांना विचारावं, त्याचं आपल्याला समाधानकारक उत्तर मिळेल अशी मी ग्वाही देतो. प्रत्येकाचे जे काय प्रश्न असेल एकेकाने शांततेने प्रत्येकाला ते समजलेलं आहे असं मी ग्राह्य धरतो आणि जे काय प्रश्न असेल त्यांनी आपले प्रश्न मांडावे अशी मी आपल्या सर्वांना विनंती करतो. एनिवन स्टार्ट कुठून करताय? कुणाला समजलं नसेल तरी आपण सांगा, आपल्याला त्या पद्धतीने मार्गदर्शन केलं जाईल. अण्णा साहेबांनी उत्कृष्ट उदाहरण दिले, समाधान बिल्डर आहे आणि साहेबांनी बोलला झाला आपण बिल्डर बस झाला.
तुम्ही पट्टे जर आणणार तर एक ना दोन बिल्डिंग बांधणार.
ॲडव्होकेट्स कोऑपरेटिव्ह सोसायटी.
कोणी आहे? साहेब माझा प्रश्न असा होता, ज्यावेळेस कोऑपरेटिव्ह सोसायटी होते, डेव्हलपर पोझिशन दिल्यानंतर कन्व्हिन्स करण्यासाठी खूप तो त्रास देतो की आज देतो उद्या देतो, कन्व्हिन्स करून देत नाही. ते रेरा नियमाच्या अंतर्गत त्याच्यावर आपण कुठल्या कायद्याने आपण काय कारवाई करू शकतो त्या संदर्भात मार्गदर्शन करावं.
See, once the RERA in place, the moment he obtains the occupation certificate, within 6 months, he has to convey the land to the society. And now this is under RERA. But if it is not under RERA, don't go for dim conveyance. Fight your case in consumer court. You will get more benefits, and the work will be done very efficiently and very speedily. So I think that there are two things which are coming into my mind. One is the lecture you have not understood, so there is no question. Or one is you have understood the lecture and there are no questions. So what it is? Yeah.
सँक्शन जो प्लान असतो तेवढा कॉम्प्लेक्सचा त्याला ते चेंज करू शकतात?
No. They have to take your consent. The home buyer's consent, 51% consent has to be there to change the plan. Otherwise, he cannot change the plan.
मी आरटीआयच्या अंतर्गत सीजीएमला एक आरटीआय गेलो होता, त्यांना विचारलं होतं की कुणी कुणी कन्सर्ट दिलेली आहे या प्रोजेक्टला हे करण्यासाठी, विड्रॉ करण्यासाठी, चेंजेस अमेंडमेंट करण्यासाठी.
Amendment करणे.
त्यांनी असं दिलं की अशी काय नियमावली नाही आहे.
No. See, for MCM, this is not there. You have to file a complaint in RERA. You have to show that I am an adoptee, I have booked this apartment, and when I had booked, this plan was there, but after that, without my consent, he has changed the plan. So your complaint lies in RERA, not with the MCGM.
सेक्शन प्लान एज पर माय नॉलेज सेक्शन प्लान म्हणजे तीनच बिल्डिंग होती, तर त्यांनी ना गार्डनच्या जागी बिल्डिंग उभी केलेली आहे. तर ती त्यांच्याकडे पण ओसी आहे त्याच्यामध्ये मिळालेली आहे.
So section 12, what it says, that whatever he has advertised in the beginning, that there are going to be 3 buildings, right? So you are an LOT, you have purchased that apartment.
Yes, LOT.
So you have to file a complaint in RERA, not in MCGM.
See, I will add certain things. What Sulaiman Bhai has said is absolutely correct, and it is hitting the nail. But in addition to that, I would like to add something. BMC, humorously speaking, BMC means bachelors and masters of corruption. This is my personal view. And I write to the municipal commissioner also in this language that it is my impression that BMC only stands for bachelors and masters of corruption. I say so because I know quite a few buildings, including the buildings of BMC, where there is unauthorized construction. Off the record, I may say, I am staying at Ghatkopar. At Ghatkopar, I will request any one of you who is coming to Ghatkopar to just stand below the BMC building. Just 1 minute, not even 1 minute, half minutes walk from the station, and you look at the building. you will yourself realize that the fourth floor is illegal because the shabby construction is there. Same is the case with M West Ward, where I have been told by some officers that that particular building, unauthorized room has been constructed by BMC officials just to store their records. I have also been told that at Andheri KOS building, which is opposite Andheri station, there also some unauthorized construction is there. Well, I will add a few more things. If you go to Mantralaya, if you go on the top floor, you cannot go by lift. You have to go one floor down, and from one floor we have to walk it out, because I am practicing in cooperative department, and cooperative minister sits on the 10th floor, on the top floor, where we have to climb one step. Now coming to your specific complaint as regards change of plan. Section 7 of the Maharashtra Ownership Flats Act is very clear, accompanied with the judgment delivered by the Bombay High Court in the case of Nina Wadia versus Venus Builder. The sum and substance of the judgment is blanket consent obtained at the time of signing of agreement or at the time of handing of possession is no consent at all. Consent has to be meaningful and effective. If you read builder's agreement of say 100 clauses, you will find 101 clauses against you. That much it is, I think even an SSC student will say you cannot sign the agreement. Yet even if the solicitor is purchasing the flat, humorously we are sometimes tempted to call solicitor as solicitor. This is just by the way for bringing this thing, the definition of professional. Lawyers, we are calling them liars. Chartered accountant means keeper's accountant. This is to ensure that all of you are active and vibrant. This definition is being spoken. But the point I am trying to make is, even if a professional is purchasing a flat, builder will not comply with that particular this thing. Supreme Court has time and again held that one-sided agreement has got no value. If you look at the agreements, practically every clause in the agreement is against you. Even when you go to purchase a flat, it is shown that you have got to sign a letter of allotment, letter of invitation that you are willing to purchase the flat. And so many clauses are mentioned, plus Sulaiman Bhai will agree with me that in that letter, there are so many things written which not even an SSC speaking student will agree for that thing. But that is way how we have to function. Secondly, just for your knowledge, now development control regulations have been amended 2034. Prior to that, FSI was one for city, one for suburb. 0.35 fungible FSI was there for city as well as for suburban. And for suburban, 1 TDR was there and 0.35 fungible TDR was there. So on a plot of land of 1 plus 1 plus 0.35 plus 0.35 equal to 2.70 was permissible. In Vikhroli today, for MADA properties, including the treatment benefits, the FSI that can be consumed is 12. So if any of your societies are going in Vikhroli area in MADA, you have to ask the bidder while negotiating what is the total amount of construction that you will be doing. That will not be liked by Samadhan and our Deepak Paikrao, because they have got interest in real estate also. Jokes apart, so this is what is permitted, and practically in MADA colonies and complexes like here in Vikhroli and Ghatkopar, we find that it is not possible to consume that much FSI because this is linked to the size of the plot, and plot size, as we know, is normally very small. So this, while negotiating, you have to give importance to this particular fact. As far as what we are telling that regarding change of plans, countless times, out of 100 times I would say, BMC will pass the plans because they know how that cordial relations are there with the builders lobby. So they grant it for that. They will even give you a legal opinion. But if you go to the court of laws and say that this plan is changed without my consent, in spite of the fact that in the agreement it is mentioned that the builder has got blanket permission. Agreement is just a contractual obligation, and what is written in the statute is a statutory obligation, and that statutory obligation always supersedes. Just for your information, most of the builders, what they do, they don't load the full FSI at the beginning. They only, for example, a redevelopment building is taken. They only take CC. For example, today it is a 4-story building. Then 4-story building, whatever FSI is available, that they will take 1 or 2 floors. They will execute the agreement also with members of permanent alternate accommodation agreement. And what mischief they do, they don't mention your flat number which is being allotted to you. They will only write your allotted flat number, and then they will say we'll execute a deed of rectification, which will be done after the entire building is constructed, full it is CC is loaded. So as a flat purchaser, you or your client, whenever you are purchasing a flat, you have to insist for full CC or the CC for the flat on the floor on which your flat is situated. For example, your flat is on 4th floor. You have to demand the CC for the 4th floor, because tomorrow there are so many stalled projects. Sulaiman bhai will also draw your attention to that fact. That what will the builder do? He has not invested in anything in the project. Builder is a visiting faculty in your life, the life of the building. What he does, he gives promises very big things, but construction cost. And that also what he does, he takes money first from you and then he invests. Days were there when even farmers used to become a builder and estate agent. All they needed was a plot just to put one board on the plot. From there they could get income. So what I am trying to urge you as a flat purchaser, if any client approaches you, you may consider requesting the flat purchaser to take a bank loan of say 50,000 or 5 lakhs or 50 lakhs, whatever the pocket of the purchaser is there. But if you take a total loan, bank will scrutinize the papers in a better manner compared to an individual like search, etc. taking. And amongst the bank, the best banks to look and verify the title are State Bank and HDFC is my personal view. Cooperative banks are very cooperative. They will do anything and everything. And so we have Chetna Bank and so many other banks. We know how the situation is. But it is advisable for you to tell your client to take a loan preferably from State Bank or HDFC Bank. Secondly, don't fall for anything from what builder is saying. Let it be properly recorded and documented. Secondly, I always tell my flat purchasers, when you are going, you take your wife, sister, girlfriend or a secretary with you. And when you go there to the builder's office, let her stand very innocently and with the modern gadgets, record everything A to Z. Who knows something like payment in cash, the promises being made by the builder, because the tongue does not have a bone. So occasionally it slips. So all these things will be properly documented, and when you will take advantage of advocates like Sulaiman bhai, you will become a real Sulaiman.
आणि यानंतर अजून वासवानी साहेबांचं तसेच माजी न्यायाधीश साहेबांचं सुद्धा आपल्या इथे लेक्चर ठेवणार आहे. आपल्या वकील बांधवांना मार्गदर्शन मिळावं आणि त्याचा जास्तीत जास्त फायदा त्यांनी वकिली व्यवसायामध्ये करावा. त्यासाठी काही माजी न्यायाधीशांचं, वासवानी साहेबांचं आणि इतर जे वरिष्ठ प्रत्येक क्षेत्रामध्ये जे पारंगत असेल त्यांचं मार्गदर्शन घेणार आहोत आपल्या वकील बांधवांसाठी. आणि हा जो कार्यक्रम आहे आपण आलात आणि मार्गदर्शन घेतलं, आपलं मनापासून मी आभार मानतो. पुन्हा एकदा धन्यवाद.